Good morning, everybody, and I apologize for the slight delay. It's a technical thing that they have to make sure everything is up and going. My name is Jane Kirtley, and I'm the Silha Professor of Media Ethics and Law at the School of Journalism and Mass Communication here at the University of Minnesota. And it's my privilege to welcome you all here on behalf of the School of Journalism as well as the Silha Center to our special symposium honoring the legacy of the late Professor Don Gillmor. The title of the symposium, as you know, is How Far From Near, and what we're doing today is commemorating the 50th anniversary of the landmark Supreme Court decision, New York Times versus Sullivan. Before I introduce our opening panel, I want to take a couple of minutes to thank many of the people that were responsible for today's events, and also to give you a very brief outline of the cases and sort of the rationale that we had as we put this conference together. So let me do the housekeeping matters first. First and foremost, I really want to thank the many people who have contributed to this event, to making it happen. We have a variety of people from the School of Journalism staff, including Mary Ackerts, Sue Colling, Scott Dirks, Julie Golias, Sarah Howard, Nick Howe, Wally Swanson, and especially Elaine Hargrove, who is a program assistant in the Silha Center and who really did the yeoman's task of putting this program together. We also have several graduate students that are affiliated with the Silha Center: Cassie Batchelder, Casey Carmody, Brett Johnson, and Alex Flicides, some of whom are here now and some of whom will be here throughout the day. Make sure you say hello to them. They are truly the future that we're honoring in part today as we honor Don's contributions to scholarship. I wanted to mention that if you are seeking Minnesota CLE credit, there is a sign-up sheet where you checked in. We understand that the Minnesota Bar is not fanatical about that, but we do want to have a record. So the ID number for this event is inside the program, so you'll have that you need. But if you would like to sign in for CLE, please do so at some point today. I also wanted to mention lunch. Many of you know that we are having a buffet lunch here between the end of the last panel and Judge Robert Sachs' keynote address. It's reservation only, I'm afraid. We actually filled our capacity. If you're wearing a name tag, that means you've got a seat at the lunch. And I wanted to just say that we have a relatively short amount of time for lunch. It is a buffet lunch. So I know it's very tempting at the end of a panel to linger, but I'm going to ask that you please not linger, that you move with all deliberate speed to the forum area, which is to your left as you come out of the auditorium, go through the buffet line, and have a seat. Unless your name tag has either a blue or red stripe at the front of it, the seating is open. You may sit with whomever you wish. If you do have a stripe at the top of your name tag, then there are two tables, one with a red decoration, one with blue decoration, and we ask that you sit at those tables. But other than that, we hope you'll use the lunch as a time to catch up with old friends and maybe make some new ones as well. So, enough about sort of the housekeeping measures. I now want to get into the substance of what this is all about. Our keynote speaker, Bob Sack, from the Second Circuit U.S. Court of Appeals, is an old friend of mine, and I was delighted when he agreed to come and do the keynote address today. We had dinner last night, and Bob said to me, "So I don't understand why you're doing a conference on Near and Sullivan. I don't really see the connection." He said, you know, yes, Near is probably the first case where the U.S. Supreme Court applied the First Amendment to a state statute. And of course, we know and we'll be talking about the interplay between state law and constitutional law in Sullivan. He said, but other than that, I don't quite see it. Well, to me, there's a very clear connection. And it is that the publications that were involved in Near and in Sullivan both dealt in a very real way with an antiquated concept, which is seditious libel. That is, the right to criticize government and government officials. Now, clearly, Jay Near, with his Saturday Press, went about this in a very different way than the sponsors of the Heed Their Rising Voices ad that appeared in the New York Times. But at bottom, they were both doing exactly the same thing. They were calling to account government officials in language that was inflammatory to some people and led ultimately to, I think, two of the most important cases for the Supreme Court to ever have decided on First Amendment issues. There's a resume of these two cases in the program and a little take that we at the Silha Center made on what we think is their significance. But I don't want to steal the thunder of our panelists today, other than to say that I think that when you think about the First Amendment and freedom of the press, in the United States, and I would even go beyond that to say around the world, these are the two cases that everybody talks about. And they really are uniquely American in their absolute approach to the idea of protecting the rights of people to freely express their views about government and government officials. The other thing that I think is significant about these two cases, and perhaps more significantly for Sullivan, is that they raise an important question, which is how does government deal with the question of truth? When I was in Romania a few years ago, I was at a meeting, and one of the people that was in attendance stood up and he said, I just have a question, which is how do we make the press tell the truth? And I thought that that was a really interesting question. When you think about the legacy of Romania at that time, how it was coming out of the Ceausescu regime, where government had lied and lied and lied, and the press had been complicit in that, you could understand why people would sort of be crying from the heart, can't we have a press that tells us the truth? But as you know, many of us have been reflecting over the last week or so, the question of what is truth is a very old and often very unsolvable question. And I think here in the United States, we have a real aversion to the notion of government telling us what the truth is, or much less trying to enforce some regime of truth in terms of what the press is going to do. But it's a critical question, isn't it? Because if we don't have truthful information, we can't be informed citizens, we can't engage in democracy in a meaningful way. So I think one of the things that I'm sure both panels will be addressing today is what the impact of the New York Times versus Sullivan decision has been on truth in the public sphere, truth in public discourse. Because there are those who say that because the Sullivan case turns so centrally on the issue of fault, that is demonstrating that news organizations knew or had reason to know that what they published was not true, the actual malice standard, that somehow the truth test has become less important in the libel context. And is that really serving the public interest and public concern? It's certainly something that the Supreme Court has been looking at. There was a long lull before they had a libel case in recent years, but there have been a couple this term. One, the case involving Air Wisconsin and some communications to the TSA. And the other one that was just argued yesterday, the Susan B. Anthony's List case, which deals with the constitutionality of an Ohio statute that would make it a crime to publish false statements in the context of political campaigning. It'll be very interesting to see how that case plays out. But I mention it just simply to point out that this is a fresh issue, that's an ever-new issue. It's not just something that was wrapped up 50 years ago with the New York Times versus Sullivan case. And indeed, in my experience, as I said, it's not only that it's not wrapped up here, it's continuing to influence jurisprudence and legislation all over the world. Which is my segue to introduce our moderator for today. Let me again just add that if you've got your program, you know that there are detailed biographies for all of the panelists here, as well as the moderator and Bob Sack. And my own view is that we're not going to reiterate all that. You can look at it for yourself. But I want to very quickly identify Ev Dennis, well known to many of you, currently the Dean and CEO of Northwestern University in Qatar. He has had an illustrious career, including being at the Fordham Business School, Dean at the University of Oregon, founding director of the Media Studies Center at Columbia. He earned his PhD here under Don Gillmor and taught here for 9 years before he moved on to other things. So he is absolutely, eminently qualified to be the person to moderate our first panel this morning, our academic panel. And I'm sure that Ev would say this, but just to make sure, I wanted to mention that the people that are on this panel today are all people who were students, advisees, or Don was on their committee. So they all have a connection to Don Gillmor. It is really a true celebration of his legacy with this panel this morning. So, Ev?
Jane, thank you very much, and welcome everybody to what I think is not so much a celebration of the Sullivan case or its connection to the Near case, which, as Judge Sack indicates, is somewhat fragmented in some way. I was rereading the Sullivan case the other night and realized there was only one citation to Near in the case, and it's in a footnote, but it's an important footnote. And this morning, as we talk about how far from Near, a question I think Don Gillmor would have liked to explore, and when I reread the cases, I could hear his voice in the resonant sounds of the phraseology of some of the language, the robust public discussion trumping the whole notion of the protection of public officials, the whole business of no prior restraints and subsequent punishments, and many other phrases that in Don's many lectures one would hear. And Don Gillmor was not one who engaged in self-advertisement. I remember him once seeming very disgusted at the title of a book by Norman Mailer called Advertisements for Myself, and it was not in his nature to do that kind of thing. And so I think the best way to celebrate Don's legacy is indeed learning in the advancement of knowledge, to move on beyond the work that Don did and to draw on some of his students to do that work. And I think we five are among the 23 PhD holders that Don worked with over his years here. And of course, he worked with hundreds and hundreds of master's students and thousands of others, and a wonderful, wonderful legacy here. And for me personally, it's a joy to be back in these precincts and to have seen Murphy Hall transformed the other day. It was sort of like deja vu in reverse. I knew I'd been there before, but nothing looked the same. So that's probably a good way to start a conference like this one. As I said, our panelists have insisted that this not be a cause simply for celebration, or as one commentator some time ago said of the Sullivan case, a cause for dancing in the streets, but instead a chance to look at this case and its connection to the Near case, to talk about the notion that Don Gillmor often mentioned, First Amendment exceptionalism, and to connect them in that way. And one other connection I can think of is in prior to the coming of the Silha Center, which is really Don's real legacy, not this conference. This conference is a piece of a larger mosaic, and under the leadership of Jane Kirtley, moving ahead on so many fronts. But Don organized a conference on the Near case at the time of the publication of Fred Friendly's wonderful book, Minnesota Rag. It was out in Wayzata somewhere, and Anthony Lewis was there, and a lot of amazing people. And I remember that conference being just a time of joy and discussion, and let this one move in the same direction as that one did. It was a really wonderful time. What we're going to do this morning is to I'm going to ask some questions. I'm going to pretend like I'm Don doing a dissertation oral or something like that. Not really, but and my colleagues know what some of the questions are, but I'm going to mix them all up as Don liked to do, and ask them perhaps in a somewhat different order. And they're all eminently qualified to do this. As Jane mentioned, their bios are here. David Allen, associate professor in the School of Journalism and Media Studies at the University of Wisconsin in Milwaukee. Robert Dreschel, who is the James E. Burgess Professor in the School of Journalism and Mass Communication at the University of Wisconsin-Madison. Elizabeth Banks Hinman, who is an Associate Professor at the Edward R. Murrell College of Communication at Washington State, and Herbert Terry, Professor Emeritus in the Department of Telecommunication, Indiana University, Bloomington. Some of us went to school together. We all kind of know each other from in and out of the field over the years. And by the way, the field is a term that Don Gillmor truly loved. When he talked about your contribution, he cared about institutional loyalty, and he cared about the law, and he cared about many other things, but he cared about contributions to what he called the field, and I think that's the aspect of the Silha Center that resonates most importantly. And the field to Don was a mixture of industry and the academy. It had to do with law, and it had to do with ethics, but it had to do with contributions to knowledge and systematic analysis. And so that's why this panel exists today, and perhaps a reason why we're here. So why are we here? Well, we're here to look at these two cases and to think about their impact, their importance, to look at them through the eyes not of celebrants, but as people who are thoughtful and perhaps critical of some of the impact. There are upsides and downsides, although no one here, I think, would argue perhaps that Sullivan shouldn't have been decided in the way that it was. But I'm going to begin this morning by asking David Allen perhaps to take on this question, and perhaps any of the others, and then we'll ask everybody different questions. As we talk about the Near case, and Jane sketched it out, J. Near and the Saturday Press, a scurrilous anti-Semitic fringe publication that was operating in these precincts back in the period when the Near case was decided. And I'm going to ask this morning, though, how and in what ways did Near v. Minnesota set the stage for New York Times v. Sullivan? Considering that the Supreme Court in Near interpreted the First and 14th Amendments to forbid previous or prior restraints of publication, but allowing for subsequent punishments in the instance of libel unless the publisher could prove that the truth was published with good motives and justifiable ends. So, David, your thought about that?
Well, I think
just to put you on the spot. Yeah.
To start off, right? That's fine. You know, I think the way that I look at Neer and Sullivan is and I think we'll talk a little bit about this later, is that I really sort of see them less as freedom of the press type of cases and more what they say about the place of dissent within a democratic society. And I sort of read them that way and look at their place in these larger historical movements. And I think how we see Neer is that we start placing it in the move away and the limitation on the powers of government. So you see a tremendous emphasis in Neer on limiting the use of what they referred to at that point as the police power at that particular time. And the Neer decision is remarkable in that it spends a lot of its time sort of taking that apart, trying to sort of limit the power of the police power and the government to use the police power as a way of controlling the press. And that sort of sets up, I think, the Sullivan decision in some very important ways as well. And so by the end of the 1930s, you see the police power sort of be eliminated from the whole discussion of freedom of expression and First Amendment rights and things like that. But I think with the Sullivan, even though the Sullivan decision starts to continues on that tradition, it sort of sets us off into a different way of understanding and how it might come back into play. And I think it's kind of complicated to understand, but I think what we start seeing with the Sullivan decision is what I often refer to as the categorization of public life. And so we start placing people into, these are public officials and public speech and how we think of that. And so this idea of the police power, even though it's eliminated in the Neer decision, it comes back into play, I think, through this categorization of public life later.
So what do you mean by the categorization of public life?
By putting people into categories, you know.
Example?
Say, yeah, of like public
See,
officials.
I'm trying to be Don.
That's fine, yeah, that's fine. You sort of made me sweat a little bit when you started saying it was going to be like my preliminary defense all over again. But, it was not a wonderful time in my life that I want to celebrate. But you know, we start putting people. If you're a public official, you have certain responsibilities. You have to prove certain things. If you're a public figure, if you're a limited public figure, those sorts of things. And so you start putting people and things into categories. And you know, in the 1960s, especially, as we know that, especially for the Warren Court, that categorization was incredibly important. They saw categorization as a way of trying to protect freedom of expression. They saw that as a very powerful way.
Categories being public officials, public figures.
Public figures,
yes,
and then ultimately it became sort of in the public forum. We started placing like public parks as traditional public forums, and so that categorization became very, very, very important. And even one of the things that I find most remarkable about the Sullivan decision is what happens after, because I think the Sullivan decision sort of sets up some things that really happen. And you see Justice Brennan's decision in the Sullivan decision as building on this categorization, but you start seeing in other cases after that how Justice Brennan starts to have some second thoughts about that categorization.
Okay, why don't we hold those second thoughts, and I'm going to ask Bob if he would connect us between the notion of no prior restraint and subsequent punishment and take us into the Sullivan case. With such terms as reckless disregard, and that's a category, I suppose, of defining malice, is it not?
Yes, but not malice exactly in the same sense that we would tend to think of it in lay terms, and I think, in fact, actual malice was an incredibly unfortunate choice of words to use to describe what that standard was. I'm going to back up just a little bit, just to build a bit on what Dave said and make this transition. I think, you know, there are a lot of things that are going on in Neer, but one of the odd things about it that I've discovered, at least when I use it in class, is it's frustratingly and surprisingly difficult to read that case and find in it anywhere an explicit statement of what it actually means, what it actually holds.
Isn't that what lawyers always do?
It's between the lines,
No.
you know? So you can read the case and you can come away from it realizing that, well, what they seem to be saying is that before you can have a prior restraint, the government has to have some incredibly important interest. And you can read between the lines and you can see that it seems to say that if there's an alternative other than prior restraint, such as a libel suit after the fact, then you can't have the prior restraint. But oddly enough, they never directly say those things, which, well, I'm not sure what to make of that, but it certainly makes for a more flexible possibilities in interpretation. You know, as we think about it as we move from Neer to the Sullivan case, obviously they both make a strong statement about the importance of political speech and protecting political speech and the idea that political speech is at the core. They both say a lot about sedition. Neer strongly, again, implying that having a law of seditious libel is most likely inherently unconstitutional, although, again, they never explicitly quite say that. And it's much more explicit, of course, in Sullivan, which also explicitly, essentially, finds the 1798 Sedition Act to be unconstitutional, about 160-some years after the fact.
A little late, but
better late than never. I think there's an element of originalism in both of these cases. I think Neer is strongly predicated on the history or the meaning of freedom of expression in British law, English law, and in the earlier experience in this country. And we get that same thread again picked up by the court very strongly in the Sullivan case. And of course, technically, Sullivan couldn't have happened at all had Neer not begun by first reminding everybody that the restrictions, the limitations imposed by the First Amendment on government are applicable, clearly applicable to state governments and not just the federal government. And so if there was any question as to that left up in the air after the Gillmor case back in 1925, that was clearly resolved. But without it, of course, New York Times versus Sullivan would not have been a case that was heard at all. Neer, of course, leaves the door open to the question of libel suits after the fact by public officials. And that, of course, is exactly, again, where Sullivan picks up on this theme and then substantially limits the possibility for public officials to sue for libel. Now I'm struggling to remember what your original question was,
Well, my original question was...
You mentioned actual malice.
Indeed, yeah.
Yeah.
Well, I added that on because we were talking about categorization and how to define actual malice, or how to define the terms that come out of the Sullivan case being knowing, reckless disregard and knowing falsehood, which builds on the notion in Neer, of course, or of good motives and justifiable ends. There's a linkage there.
Which is off the table after, at least as far as public officials are concerned, that good motives and justification is after Sullivan is off the table. Because inherently Sullivan is going to require the public official plaintiff to prove the falsity of the libel, because how else can you prove that there was knowledge of falsity or reckless disregard for the truth? But by stopping short of making it impossible for public officials to sue successfully at all for libel, the actual malice test, as seemingly protective as it is, nevertheless is an invitation to more and more litigation, just if nothing else to flesh out the meaning of that concept. Knowing falsity may be one thing, but reckless disregard for the truth. And the Supreme Court hasn't, I think, been terribly helpful in addressing that question. They've done a lot better job of telling us what kinds of evidence does not constitute actual malice than they have telling us what.
Of course, they never met internet trolls. They tended to find reckless disregard and four-part harmony, I suppose, in some ways. I'm going to ask Beth if you would connect us here on the question really of, I know you're interested in some of the implications of the case for ethical conduct and that sort of thing, but after Sullivan come the Sullivan progeny cases. And they, I think as you've argued, they tend to get involved from time to time in monitoring the behavior of the press as much as anything.
Okay, thank you. I first want to say Don was on my committee. He was a wonderful mentor, but my advisor, Hazel Dicken Garcia, is also in the audience, and I'd like to say hi to Hazel. You know, my work really, I try really, really hard to blend law and ethics, and particularly talk about how the press is held accountable within the law and by other means. So I'm going to argue, just for the sake of argument, if nothing else, that the New York Times versus Sullivan case really issued in an entirely new era of discussion of media ethics. And obviously the rulings tend to go in favor of the press, but if you look at the discussion that the court has among the justices have among themselves, they're talking about ethics. So for example, I have to read here. I have a quote from my all-time favorite justice, Byron White, who loves nothing more than to hold the press accountable. Justice White wrote, New York Times rule brought about two evils. So New York Times versus Sullivan is actually an evil case. First, the stream of information about public officials is polluted. It remains polluted by false information. And second, the reputation and professional life of the defeated plaintiff may be destroyed by falsehood that could have been avoided by reasonable effort to investigate. So to me, Sullivan and the progeny cases really, again, while they go in favor of the press, the justices don't like the press very much. And they argue that the press really needs to be held accountable. And in fact, they argue that more often than not, the press is actually harming public morals, and that by behaving unethically, the press is harming democracy. And really the best way to democracy is to have an ethical press. We see that in case after case after case.
Go ahead.
No, go ahead.
No, please continue.
And the justices really struggle with that. I mean, they have a conflict. They know that they're supposed to protect the press, and to protect the press provides for the government watchdog role. But then when the press is unleashed, they go too far.
Thank you. During the time of all that dancing in the streets we heard of just a moment ago, one publication, the Quill magazine in 1964, declared that New York Times against Sullivan had, quote, all but abolished the law of libel. And I want to ask Herb Terry, was that an overstatement? Did that not anticipate what would be happening later in the progeny cases?
Well, I think certainly in the progeny cases, the law of libel got restricted. You've talked about categorization. You know, the court subsequently extended it to other categories of libel plaintiffs. Did it abolish the law of libel? Well, probably not, but it certainly made recovery much more difficult. One of the things that Don and I, often debated was how you studied communications law. I argued with him a lot that, one of the things that school journalism and mass communications had taught me when I was here was to focus on the process and effect of communications, and I focused a lot on the process and effects of communications law just as much as on its substance. The effect of those cases certainly was that well, maybe you should be careful what you wish for because you might get it. The wish in that court in Sullivan was the debate on public issues or public affairs should be robust, uninhibited, and wide open. We began to get that with increasing fervor in subsequent years, not only in libel, but in other areas in telecommunications law that I pursued for a long time. The Federal Communications Commission used to have a fairness doctrine and got rid of that, and we get Rush Limbaugh and all of this sort of thing. The other thing I wanted to say at some point here, and again it reflects disputes or differences Don and I had from time to time, particularly when we worked on subsequent editions of mass communications law. I've always interpreted Sullivan primarily as a civil rights case rather than as a First Amendment case. They faced a situation where the New York Times was getting treated badly in Southern courts in the context of talking about the civil rights movement. You asked us to think about what the long-range consequences of the cases were. I think the long-range consequence in that case was that both the civil rights movement and the New York Times continued. And what they had to say to reach that was in a couple of ways fundamental. I mean, they fundamentally did change American libel law, at least when it came to public officials. And second, going back to some current issues today, it's often forgotten, but they had to reach the question of how the First Amendment applied to advertising. That was an advertisement. It wasn't the editorial creation of the New York Times. And at that time, they had often said First Amendment doesn't apply to commercial speech. Well, here they had to come up with the idea that we'll apply it to commercial speech relating to ideas. In a very broad way, you get Citizens United kind of out of that once you start saying that commercial speech, as well as the content originated by the media, is subject to First Amendment protection. So I think there are lots of consequences of it, but did it make it more difficult for people to successfully sue for libel? Sure.
Thank you. One of the things that we sometimes lose in the more abstract treatment of these cases, and you bring to mind the ad itself, heed these rising voices, the people who signed that ad, the litigation against them in the courts of Alabama and on after that, and you think of the progeny cases, and you think of names like Carol Burnett and Wayne Newton and Colonel Anthony Herbert and some of those characters. Do we lose something in relegating these cases, the study of these cases, essentially to the holding of the court and to conferences that involve the lawyers and the judges and everybody but the people who were involved in the first place? Silence?
This is an open one?
Open.
Yes, no answer?
I guess I would, I can respond to that by saying I think there is a little bit lost, because I think one of the things that I always find remarkable about the Sullivan decision, it was a jointly decided case, and we've sort of over the years tend to see that as a freedom of the press case, and what's lost is the story of the African American ministers who were also the victims of libel cases, and that's sort of over the years, as we look at the Sullivan case, we sort of see that as being kind of read out of the meaning of the court or of the decision in public life, and we see it. I see this repeatedly all the time, where people write about this and see that the Sullivan case is primarily a freedom of the press case, and and in some of it might be a part of the problem of the Supreme Court and its decision as well, because it says sort of remarkably little about the freedom of the African American ministers to take out the ad in the New York Times and those sorts of things. There's a little bit of mention of that, but most of the emphasis is really on the New York Times. And so I think if that's what you're getting at, Ev, I think there's that sort of alternative meaning of the case that sometimes we lose in the larger discussion of it.
We also lose that alternative meaning over time. As I said, I had the opportunity to work with Don on several editions of mass communications law. If you look at the textbooks used in journalism and mass communications program, law books, that sort of thing, generally speaking, even landmark cases get shorter and shorter excerpts as the law develops.
No, that's as writers of textbooks, as I well know, get lazier and more tired.
Well, every time we had to deal with it, we had to cut back on how much of Sullivan we reprinted. And eventually it comes, the Supreme Court decided this thing, and it said public officials had to prove actual malice in order to recover most libel evidence. Maybe we say a little more than that. But yeah, it does get lost. And I think we're particularly at fault when we're communications scholars of doing that. I've always argued that I didn't come here to get a law degree. I didn't come here to major in mass communications law. I came here to understand communications. I think our obligation as scholars more and more is, and it's hard to do in current academia, to not sort of silo ourselves into the discussion of what the court said and what the law is, but try and understand that in the context of its time and understand the broader long-term consequences of these things for public. That makes it easier to start trying to figure out what the impact of this case, if you want to go that way, is on things that were somewhat unanticipated in the time and the development of social media and that sort of thing. Then you can begin to see how impact beyond the language of the court can be understood.
Can I just add, too, that in terms of the people who are directly affected, the parties to a case, I think we need to keep in mind, for example, that there would be no Neer versus Minnesota, or the precedent that would remain, at least within the state of Minnesota, would have been a victory for the state, had it not been for Colonel McCormick stepping in and deciding to pay for
Colonel
Neer's
McCormick, the publisher of the Chicago Tribune.
Jumping in and agreeing to pay for Neer's appeal to the Supreme Court. He didn't have the money. And so it cut both ways in that case in terms of the dollars. On the one hand, as the four dissenters in the Neer case point out, it's ludicrous to suggest that people who might have been libeled by J. Neer should sue him for libel because, you know, you can't get any money from a guy who doesn't have any money. So what would be the point? There's no remedy. It doesn't work. And yet, on the other hand, you have Neer, whose case would never have made it to the Supreme Court had it not been for the intervention of somebody to pay his bills, while many mainstream media, I might add, were supportive of the state of Minnesota more than they were supportive of J. Neer. And I believe one of the parties mentioned even in the case as being targeted by Mr. Neer was none other than the Minneapolis Tribune at the time. So I think the resource issue is a significant one, and it probably skews the very kinds of cases the Supreme Court hears in the first place. It's inconceivable, it's just wild speculation on my part, but that one reason so many of the libel cases at the Supreme Court have involved the media is because it's media who have the means or the insurance to be able to afford to pursue litigation. Whereas if many of us in this room were the targets of a libel suit, we'd be on an entirely different footing. We probably couldn't come close to paying the expense that it would require to get our case into the legal system, certainly at any kind of appellate level, and the very suit might be ruinous to us. So I think this business of the victims is an important one, or not just the victims, but the perpetrators, for that matter, that really does get overlooked.
Right. So you're saying really there's a larger cast of characters, and maybe we don't
Absolutely.
do much on the sociology of these cases because there are many players, there are people paying for the costs. On the other hand, there's some very litigious people who hang on
Right.
forever and ever in all of these, and this is a submerged part we don't see much of. Before we get away from this being a speech or press case, though, I wanted to recall a Cass Sunstein article where he wrote, asked the question, what is the most important free speech ruling in the history of the U.S. Supreme Court? And then he goes on to say, the best answer may well be New York Times against Sullivan, when the court ruled for the first time that the First Amendment shields speakers and writers from libel suits. I wonder if you agree with this and whether you see the question of First Amendment exceptionalism coming in here. The First Amendment for whom? Much of the discussion and much of what's written about the Sullivan case has to do with the press. And of course, the fact that the New York Times name is there forever might play a role. And the New York Times doesn't always have a 50th anniversary edition for every case that comes along that could be celebrated. What about that? The First Amendment exceptionalism, what has come out of this? Who has a stake in this? Is it something that's applied broadly to parties other than the press, other than the media, or is it still seen pretty much as something that's applicable to the media itself?
I think as
Beth,
we
would
see
you
the
like to-
rise, particularly of the internet and social media, that's the question, isn't it? I mean, who is a journalist? And we were asking that question when we were in graduate school, David. And it's just laughable to think, 30 years ago, 20 years ago, that we were asking that question, because now everybody's a journalist. And who does it apply to? The case that was argued yesterday, Professor Kirtley mentioned, the ultimate question there is an organization is asking for permission to make false statements when it comes down to it. They know that the billboards they want to put up about members of Congress are false. And they're pre-suing to say, we would like to make false statements about people. Is that really what New York Times has led us to?
Well, I think there's also, I think, a question as well that plays into that, which is in the Sullivan decision, especially, I think you see sort of it reflecting trying to find a way to protect the press as an institution, right? And And during that period of time, there was a lot of discussion that the press was special, and they were the only institution mentioned in the First Amendment and carved out for special protections. And I think a lot of those ideas have sort of faded away. It's the rise of social media and other things that have done it. But it's also reinterpretations of a lot of those things of what they mean. You know, like Justice Scalia has for years and years argued that, you know, there's nothing special about the press as an institution, that the First Amendment simply means you have the right to speak and that you have a right to publish whatever you want to publish. It's not giving protection to special institutions within society. So I think there's a lot of forces that are moving away from that idea that was sort of ascending, I guess, in the Sullivan decision in some ways.
David, you quote Lee Bollinger, the now president of Columbia, former dean of the Michigan Law School, on the case, and he says that there's arisen a jurisprudence of and for the press, but later notes that Justice Brennan's decision can be read as much as a defense of freedom of speech for private citizens as the defense of rights of the institutional press. So you think that holds now in recent cases?
I think we're probably seeing even more of that happening today, that it's really sort of challenging that idea. I think that the press is special. Whether that's a good thing or a bad thing, not so sure about that. But I think we can have that debate about whether that's a good thing or a bad thing. But I think increasingly that idea that the press is special and the press deserves special protections under the First Amendment, I think that was a very important idea at that particular time. But I think that's the alternative interpretation that you could come away and offer with Sullivan. One of the things that I've always found interesting about when my students read the Sullivan decision, they always come away sort of, and I throw the Lee Bollinger quote at them, and they go, I don't get that. How does it carve out a special protection for the press? I think that kind of emerges over a period of time, as Herb and other people have talked about. It's not necessarily something that perhaps is inherent in Justice Brennan's decision, but something about rather probably how we have come to interpret that over the years.
But even Chief Justice Berger, I believe it was in New York Times versus the United States, the Pentagon Papers case, referred to the press as, quote, the necessary representative of the people, unquote. That's not true anymore?
But if you look at Brennan's argument in Sullivan, he's really making a political speech argument. I mean, the famous caustic, uninhibited, wide open, robust argument, that's a political speech. It happened to be about the press, and it happened to be about the civil rights movement, but it was really about political speech when it comes down to it.
So then the Times on March 8, 2014, celebrating naturally this case, argued that our understanding of freedom of the press comes in large part from the Sullivan case. Its core observations and principles remain unchallenged, even as the internet has turned everyone into a worldwide publisher capable of calling public officials instantly to account for their actions and also ruining reputations with the click of a mouse. So I guess my question then would be, have social media made such chaos out of this whole area that orderly media jurisprudence no longer exists? The magisterial tests of Sullivan and perhaps Neer are gone or not?
I don't think they're gone, but I think there are a variety of changes that have come about, not just from social media, but from the development of the internet itself. So I think in terms of the press, for example, there's been a variety of things that have sort of coalesced and suddenly made different kinds of related issues more relevant, such as comments, for example, in the pages of, or the web pages or whatever, of various media and anonymous comments, and under what terms or what circumstances can the publisher, that is to say the website operator, let's say, be compelled to reveal who that commenter engaging in potentially libelous material actually was. That's both a legal and an ethical question, I think, for the media to deal with. That never happened before. But we've also had other developments that shield media, such as the provision in the Communications Decency Act that largely immunizes website operators from liability. So you have the protections both of the Sullivan standard, and maybe I shouldn't say just the Sullivan standard, but the Sullivan and progeny standard, but you also have backup from it. And for that matter, at the same time, the fairness doctrine has been gone now for upwards of 20 years, I guess. And so that too has at least facilitated more and more vituperative comment and material in broadcast. Now we're actually at a point where, depending on how the Aereo case comes out, broadcasters are threatening to simply go entirely to cable and satellite, and we'll lose all. The argument is we might lose over-the-air broadcasting altogether. So again, if that were to happen, which I very much doubt, but if that were to happen again, whatever breaks, whatever is left of any kind of regulation by the FCC on the content of broadcasting would be gone as well. So I think we have to think more about things than just social media, which of course can be and have been a hotbed of libelous, mean, nasty material. Also, I think we have to keep in mind that the Sullivan case talks about, not surprisingly, given that it's libel law, it talks about false speech. It's about false facts, in essence, or I guess that's sort of a contradiction in terms. But whereas an enormous amount of the expression that is, I think, the most obnoxious is actually opinion, or what the law would regard as opinion. And it's, I think there are probably cases that do delve into this, but I think this distinction between what's an opinion and what's a fact is another thing that is in part a legacy or re-emphasized by the Sullivan case. And it's almost as though there's an assumption that, well, we can't be hurt by opinions as much as we can be hurt by false statements of fact. And I think that's absolutely wrong. I would think that every one of us in this room have at one point in our lives been wounded by some kind of a nasty opinion or not. Not that I'm arguing for opinion to suddenly become subject to libel law, but I think all of these play into this because social media, a lot of the stuff,
let's take that for a moment in the realm of technology, and I want to get to Herb on this. The assumption was after Sullivan, I presume, in some of the progeny cases, that the ruling was sort of seamlessly applicable to most all media platforms, with the possible correction for broadcast media, which were under a different regime of regulation. And today we have this kind of open world of social media and examples. For example, in recent times when corporations are attacked by internet trolls, which I referred to earlier, the advice of Public Relations Counsel is not to attack the trolls and ever answer them at all, but to kind of fill the system full of other material and let the words of the troll move through the system. So the free and open debate, the notion of truth and falsehood battling is not recommended at all. So keep your mouth shut, don't say a word. Let this thing pass like, a bad bowel movement or something, and then on goes, the better material comes through. And so it's a different matter. So what about that, Herb, in terms of technology and whether it's social media and, the role of social media in all of this, does it make a difference?
I think it makes a huge difference. What I was going to say in response to your last question, which is relevant to the question you just asked, is that we do have to remember the simplicity of the times when New York Times versus Sullivan was decided, compared to the complexity.
The simplicity of the New York Times or the Times themselves? The Times that were changing?
The Times of the Times.
You're with Bob Dylan on that. Okay,
it was a simpler world, And clearly today it's a much more complex world. Magisterial statements from the Supreme Court are harder in our complex times. And I think they're also harder when you have a politically divided court, You know, we have, I don't think in recent years we've had very many magisterial statements that, you know, have the support of more than 6 justices, perhaps. So it's not so helpful for that. The real question for me is, is the court capable of adapting to this new media environment? I haven't listened to or heard the transcript of yesterday's arguments, but most people were looking forward to the question of whether these people, most of whom probably don't subscribe to the cable.
You want to comment on that for those who aren't familiar with?
No, the issue yesterday was an invention of Barry Diller, technology called Avio.
Yeah.
Basically what Avio does is it sets up in major television markets a server connected to thousands of little tiny antennas. Each of those antennas is capable of picking up on over-the-air broadcast signals. Somebody who buys Avio's service, according to them, is basically leasing a private antenna in a distant television market. And then they connect to that via the internet, and they can watch over-the-air broadcast television through the internet on any device, any portable device. Avio's proponents, this is just an extension of free over-the-air broadcasting and all of this sort of thing. To the broadcast networks, this is the functional equivalent of cable. Their economics have changed. They now get much more money than they used to from cable retransmission consent. They want Avio to pay, and subscribers to pay for that. The real question, it seems to be, will the court buy the legal argument, which is, the Copyright Act can be interpreted this way and we can run our business model? Or will the court buy into some broader argument that this is the functional equivalent of cable and so forth? I think it could have a very short half-life. If Avio wins, we'll be back in the question of whether anybody wants to change the
And we'll say goodbye to all of our cable fees, right?
Well, who knows? You may say goodbye to that anyway. It's another industry. To return to the broader question, New York Times versus Sullivan was decided in its time. And time marches on, media change occurs. We will see subsequent cases. We'll get it sorted out. This has been a very turbulent past 2 or 3 or 4 decades. Today, we look at a whole bunch of things and we say, well, past precedent doesn't quite apply to this. But over time, the courts will catch up. And we'll develop some new theories of First Amendment jurisprudence that will apply to much less centrally controlled, much more converged media. I think convergence is as important as issue as the emergence of social media. Broadcasting and cable and print and all this sort of thing. It used to be in separate boxes. Avio is a great example of those things mixing all together. Entertainment and news content and advertising is now all mixed up together, and that sort of thing. And that's another very broad area of First Amendment jurisprudence that is a mess right now, but we'll get interpreted.
The whole swirl out there that is very hard to follow. And back to Bob's concern about fact and opinion, I think the best statements on that come not from the justices, from people like Daniel Patrick Moynihan, who used to like to say people were entitled to their own opinions but not their own facts. These days, is it possible? Newsweek magazine at one time like to call themselves a magazine that distinguished fact and opinion. Is that possible? And here we are in a journalism communication school where people study systematic ways of gathering information and objective, impartial treatments, which are thought not to be possible. But yet, isn't that something that's part of the test? If we go back to Sullivan, knowing falsehood, reckless disregard, doesn't that have to do with facts and facticity? And how do you deal with that in a world of Fox and MSNBC and all of the other more ideologically leaning media that tell us they're covering the news and giving us the facts?
Well, Justice Rehnquist, I thought, had an actually quite nice definition of what's a fact and what's an opinion. In the Mason case, he said a fact can be proven one way or another. I mean, you may not have be able to marshal the evidence, but it's provable or disprovable.
I think one of the interesting...
David, do you think so?
Well, I was just going to say that I think one of the interesting ethical standards that kind of emerges both from Neer and Sullivan is this idea that we'll have to live in a society where this stuff happens. Chief Justice Hughes in the Neer decision said, we just have to learn to accept the good with the bad, right? As he wrote at some point, a degree of abuse is inseparable from the proper use of everything. And that seems to be the ethical standard, and in some ways it's the ethical standard that sort of flows into the Sullivan decision as well, right? That, we live in a messy, democracy is messy, right? And it's difficult, and you have to learn to deal with the messy. And I think that's really sort of the thing that often, in some ways, that connects the Neer and Sullivan decisions as well. And I think it goes to what you were talking about, that question of trying to determine facts as well. It's like, that's difficult, it's messy.
Thank you. Let's take it into another sticky wicket area, and that's what is the reality of protection afforded to the media or communicating citizens today in their pursuit of public officials and public policy? And I ask that in the context of what other legal or political impediments have been raised in the cases of Edward Snowden, Bradley Manning, Julian Assange, and any of the other folks out there who are leaking and doing what would have violated the various laws in the areas of seditious libel in the past, or certainly in treason in some cases. Is there such a thing anymore? What's the status of those cases? We know that Bradley Manning is under military justice in another place, but the others seem to be floating around there, and there's widely differing opinions all over the world about these cases. And they're very relevant, it seems to me, to the ruling in Sullivan.
Well, my first thought was that it was more along the lines of Neer than Sullivan, actually, in the sense of, and maybe not so much Neer as the Pentagon Papers case, which is, I think, a case that, although celebrated by the media and many others at the time, nevertheless is
You're talking
fragile.
about the Neer exemption?
The New York Times versus, the United States.
Troop ships and movement of...
Yeah, I mean, the Pentagon Papers case basically was about a leaker, in this case, Daniel Ellsberg. And one of the intriguing things about it is, if you do look carefully at all of the individual opinions, it's not clear that under different circumstances the outcome might well have been different, but more to the point of people like Bradley Manning and Julian Assange and Edward Snowden is the question of can these people be punished under the Espionage Act,
right,
which was explicitly suggested in the Pentagon Papers case by at least 2 justices, and to what degree might the media themselves be vulnerable under the Espionage Act? Something that takes us back all the way to, the days of Schenck and Abrams and so on, some of the very early First Amendment cases involving the Espionage Act. And the answer is that we don't know. But the government has suggested, a couple of administrations have suggested that might well be possible. And that in turn, of course, raises the age-old question that I can remember also Don emphasizing in class and any number of times, that the question of how really much of a distinction is there between the mechanism of using prior restraint and the threat of punishment after the fact, especially when subsequent punishment is intended to discourage people from speaking in the first place. Mm-hmm. So I actually see those developments, even though they've involved the release of information by different technologies, and there's certainly differences amongst the individual cases themselves, as raising some significant challenges and issues based on the progeny of Neer, basically.
I think we can.
Beth.
The modern cases, the Snowden and Assange and so on, we can go back to Neer to sort of see the conflict, because Neer really ultimately was about sort of these competing conceptions of the good. On one hand, we had, we need to protect freedom, and one way to protect freedom is allow people to say unpleasant things, to criticize, to be. Neer was not a nice guy. I mean, to be incredibly unpleasant. But on the other hand, there was the dissent in Neer basically said that Neer had harmed the morals, the peace, and the good order of society. Well, what do we want to do? Do we want to allow people to leak secrets, or do we want to protect the good order of society? And that's really still the same conflict. It's still there.
That's a very good question, and Bob, I think, offered that we really don't know, but what about journalism students? There are journalism students here in the audience. We're going to get to some questions in a moment, but what do you tell students about this? We have these cases out there. We don't know whether you should leak or not to leak, and whether you should use this stuff or not, and are you in danger of violation of the espionage laws or something like that? We're pretty clear on things like insider trading. If you're writing about, you happen to overhear something that someone says, or you're actually a player in Wall Street, and you decide you want to exercise your no prior restraint, and you go out and publish things, you go to jail. That's very clear. But what about this? What do we tell students? This isn't. I'm not finding this a very adequate answer. Maybe there isn't an adequate answer.
This gets us back to a constant dilemma that has been in this field for a long time, and is reflected in Don's career. I would tend to tell them that while the level of protection of your freedom and your autonomy and the precise definitions of it may go up and down a little bit from time to time, by and large, you live in the United States and you have a lot of freedom to publish what you can get your hands on.
So what do I do, Professor?
Which turns it into, in many instances, not a legal issue, but an ethical issue.
Well, what do they do in these circumstances?
If you lawfully obtained it, you can publish it.
You can publish it.
You can publish it, but the ethical question is, should you?
There you go.
And that's what I think we have to. That may be the other class. For a long time, I taught courses that were called legal and ethical issues, and fill in the blank. So they may be a separate class or not. But that's the fundamental lessons of all of these cases. That if you're fortunate enough to live in the United States, the government is going to leave you room to make lots of ethical and moral judgments.
I find that dealing with students and parents, two groups of people who don't like ambiguity at all, you've got an issue here of what to do for self-protection. With parents, I used to say in speeches to parents about convergence and disruption of the media system, we could proudly say, we are training and educating your young people for jobs that don't exist. They love that. You can imagine. What? I said, well, there are actually some that do exist, but there are going to be new ones that don't exist yet. So that was before Google, and here we are now. Any other thoughts about that point, Bob?
I would jump in and say that, the first thing I thought is of a comment on a student evaluation I received last semester who said, I took your class in media law, and I have to say, I still don't know how to recognize a libel when I should. And that, to me, that says a couple of things. One is, and they're sort of opposite things. One is that the class worked, and the other is that maybe it didn't work. And you're dead right about students and maybe parents as well thinking that there are unambiguous answers to difficult questions. And I think law is a classic example of that because on the one hand, you can't, as a person using the law as a tool to make a judgment about something, you can't make the outcome anything you wish it to be because there are constraints. But by the same token, it's seldom a black and white kind of question, or it wouldn't be litigated at the level of courts of appeal and Supreme Courts, and there wouldn't be dissenting opinions and so on. And it becomes a very difficult thing. It's the same in the realm of ethics, ultimately, to convey the idea that you're not right about, you can't make outcomes be whatever you want them to be and justify them somehow, but that by the same token, there are approaches to thinking your way through problems that are, in fact, highly desirable and highly useful and highly effective. But make sure you think through these things before you just do them. And, of course, for goodness sakes, don't confuse law and ethics. But that's a very difficult
but no
thing to convey.
No mechanical test, as you say.
You're right.
Yeah.
Right.
Yeah, and I think that's one of the problems of democratic life. I mean, Don and I used to talk about this. I remember it was always interesting because we used to talk about that. I think inherently society turns towards looking for easy legal answers to very difficult ethical questions, right? Because the law is an easier concept to deal with, and you can see that reflected in our society. You know, we have governmental ethics committees and things like that, and who staff those committees? They're lawyers, right? They're not philosophers, they're not ethicists, they're lawyers. And so we turn very, very difficult ethical questions that we have within society, we try to turn them into legal questions because law is viewed as being an easier thing. There's less ambiguity, whereas ethics is a very difficult thing for people to wrestle with. And I just think that's one of the problems that we have in a democratic society, is wrestling with with those real hard ethical questions.
Well, and the justices do that too.
Yeah,
They just have to vote on it, and the rest of us don't.
One nice outcome of one of the progeny cases, Carol Burnett against the National Enquirer, was she gave the award that she got in that case to the University of Hawaii to set up an ethics program. And I had the pleasure of giving the Carol Burnett lecture one year, and the audience was full of anti-press people, so it was quite an interesting experience.
Can I just throw something in about that? The Carol Burnett case made me think of this, and that is, I think one of the things that we haven't addressed is really the underlying rationales for Neer and certainly for the Sullivan case. And the Sullivan case, of course, was built on the sedition analogy. And although the court went way beyond that, because on the one hand, the court essentially made clear that it didn't even believe that Sullivan had been defamed, and he certainly hadn't been identified. And so what we really had left was a pretty clear-cut sedition case in the sense, I mean, seditious libel can be criticism of specific public officials as well, but of government itself. And yet the Sullivan test itself sort of, is a different animal, not directly responsible. There's no... But the bottom line is it's all based on this concept of seditious libel and political speech. What's happened in cases, at least after soon after Sullivan Garrison versus Louisiana case, which involved criminal libel instead of civil libel, is that the rationale has been constantly shifting. And so it doesn't take long before we get the Saturday Evening Post libel case, in which the question is, do we extend the Sullivan standard, the actual malice standard, to people who are high-profile public figures, but not public officials? Well, the sedition analogy doesn't work there, as Justice Harlan, I think it was Harlan, pointed out with considerable emphasis. So then what do? Then you have to, you start with a different rationale. You have to say, well, it's important to protect the media in these kinds of cases, or protect defendants in these kinds of cases, because there are lots of powerful, highly influential people in other sectors of society. And so it makes sense to extend the Sullivan test to those kinds of situations, even though it has nothing to do with sedition. And Justice Harlan wasn't so sure. He opted for a different test, something a little bit less than actual malice, something more than negligent, but that basically resorted to the standards of the media themselves for being responsible. So this in turn sets in motion, again, more questions about, well then, who's a public figure? And do you have to really be a really high-profile person, and so on? And so over time, the rationale, I think, has shifted, and I don't think we have always paid enough attention to the implications of that kind of shift.
Well, speaking of the implications, there are, of course, as you all know, many books and articles that have been written about the Sullivan case in the larger context, including Anthony Lewis's seminal book, Make No Law. I guess what I want to ask is, what questions about the two cases have been determined, answered, I guess, definitively, and thus regarded as settled, and what's still open for interpretation and discussion in these cases? Can you step back from a little bit and get a a broader view here and tell us maybe the result of the progeny cases and the rest. What's left? Are these still operative principles of law that can be applied in the face of social media, digitization, and globalization, which we'll talk about in a moment, or not? I'm like a congressional investigator. Yes or no?
Oh, well, I'll say something. I think it's settled that there can't be such a thing as sedition laws. I think that's okay. Clear. I think it's settled that political speech is something that's regarded as absolutely at the core of the First Amendment. And I think it's settled that, however, even in the context of libel, absolutism, any kind of absolutist arguments about protection for the media or for any other kind of defendant is off the table. But after that, I think it's it's kind of a crapshoot.
I would say, I would say truthful claims about a candidate's fitness for office would be absolutely protected. Can we say that? That's pretty narrow, but that'd be one.
Unless it's a lie. I mean,
no, that's why I said truthful claims.
Truthful. So.
Truthful
claims.
Yeah.
Okay. Yeah.
After reading Justice Scalia's opinion yesterday in the affirmative action case, I'm not sure anything is off the table any longer. It made me think of Don, because one of Don's favorite prelim questions that he used to ask was about the famous footnote number 4 in Caroline Products, and they used to stump a lot of people, if you'll remember. And yesterday, Justice Scalia called that into question, basically saying he doesn't think that's legitimate, and only 4 justices approved of that, and this whole idea that the court's whole mission is about protecting the liberties of discrete and insular minorities within society, really sort of carving out a whole new mission for the Supreme Court in the United States. And Justice Scalia is calling all that into question right now. And so I don't know if I don't know if anything's safe anymore. I don't know.
All right. Well, we've talked a little bit about the implications of a global society and digitization, and that means crossing national borders and the relevance of national borders. And sometimes during political campaigns, candidates are critical of the courts for drawing on international law from cases from other countries as a part of the American experience now, and judges travel abroad and visit other courts, as perhaps they always have, and bring back ideas. But beyond that, what's been the international impact of Sullivan, and perhaps near, in countries that are grappling with media freedom in a digital age? Not everybody has traditional media freedom. We've seen changes in the landscape of the world from the old Soviet Union. We've seen dictatorships come and go in Latin America. We've seen huge changes across Asia. We've seen the Arab Spring. Herb, you have some thoughts about this, I think, on international impact. Is there any that's discernible that you can see?
Yeah, when I left Minnesota, I went to Indiana University, and then for nearly 25, 30 years, most of my work was domestic. I taught what I learned here. I taught, how the U.S. media functioned, how our media law system worked. And then the former Soviet Union collapsed, and there was a period of time when I was fortunate to work more in the former Soviet Union than I worked in the United States. I was brought in because they were looking for new models for non-governmental media. They were looking for new models for media education. They were looking for new models of freedom of expression, and I was welcome. As that went along, it became harder and harder as they got more connected to the rest of the world. It actually became harder and harder to defend what I was saying. They would look at our democracy, and they would say, well, you have this very low record of voting. Why, are all these wonderful civics models of the United States really true? And I had to concede in many cases that they weren't. What much of that experience taught me is that we are much out of step, at least, with the rest of the world in our approach to freedom of speech and freedom of expression. You know, we are kind of unique in believing that the best way to protect the individual freedom of speech and expression is to keep the government out. In most of the rest of the world, particularly the part of the world that went through World War II, where many governments failed to protect individual rights, people died, you got things like the European Convention on Human Rights and that sort of thing, which basically says there's a fundamental right to this, and it's the job of government to affirmatively protect it and not to just stay out of the way and let things happen. At least in my experience, as the dawn of the 21st century came along, it became harder and harder just to say that we had it right. But the hardest thing to ever explain in an international context was the definition of obscenity. By the time that gets translated into Russian or Chinese,
as I find in the Islamic world,
I don't know what it means once it goes through translation. But next to that was this explanation of why in the world would we protect falsehoods. And I'll fall back on something else. I've maintained for a long time that at some point we're going to see a substantial expansion of substantive transnational media law. That there is so much cross-border flow of content and the ability to bring suits in different jurisdictions and that sort of thing, that it's not going to be just a matter of international copyright law and some other sorts of minor areas. But we will get to the point where we'll have to have something, and as that develops, the fact that we have approached it historically one way, and there are other ways, probably represented by a larger proportion of the world's population than ours, that's going to be a challenge for us.
Yeah, I would agree. If I could just add a couple of things there, in doing a lot of international work over the years. On the one hand, there's enormous admiration, respect for American legal traditions, and particularly in the media areas, among media people. I've done studies in a number of countries where I've looked at the local system and the whole relationship between government and media. And it falls far short of what we do here, no question about that. On the other hand, there's always this continuum somewhere between freedom and control. And a couple of years ago, it was 3 years ago now, and arriving in the Middle East, was asked if our school would do something to address some of the issues of the Arab Spring. And we do that almost every day with our students and trying to navigate around a civil code system, which really comes from the Napoleonic Code, a little bit of Sharia law that is sort of sprinkled in. But we had a chance to do this with the failed state of Libya, and still failed, unfortunately. But as it was very hopeful after the fall of Gaddafi, we assembled a Good Offices Conference, and we had leaders of the Libyan government, and then the Transition Council, and people running the media. And this was after the total breakdown of institutions and infrastructure in the country. It was just a disaster, a complete mess. State television was run by an actor who'd been on the job for 2 weeks, and the same was true across other media sectors. And so we brought in, very much in Don's tradition, of people from legal and social scientific traditions, and did a little bit of briefing on what kind of legal systems exist in the rest of the world. These were people who really were innocents when it came to this, and what kind of economic systems work that make media function, and what's the technology and the rules and regulations. And so we had this wonderful exercise where people had a chance to say, well, now, what kind of media system, what kind of media law does the state of Libya need or want? And we gave them choices like, you like Sweden, you like North Korea, here are some options, it's like a menu, and you kind of pick from those. It was a very interesting exercise, which led to a statement of principles of freedom of expression and an action plan, part of which got implemented, and now as the things move on. But it's an example of the dilemma you reach in these in changing societies. On the one hand, I agree with Herb that there will no doubt be a more of a global standard across a lot of areas, just by the sheer might and nature of technology and what's happening with all of the new platforms and the role of convergence. On the other hand, each region of the world has its own nuances, its own local traditions, and there's an enormous battle these days in the Middle East in particular, but other places as well, of tradition and modernity kind of coming together, not necessarily westernization. And so you have, on the one hand, people in studies that we've done crying out for putting anything at all on the internet. Let's be free and put anything out there you want to. And this very same people saying, yeah, but there has to be regulation of religion, of certain kinds of political speech, et cetera. And we have in the state of Qatar, where I am, a wonderful press law that enunciates freedom of the press on the one hand, but does not allow criticism of the Emir, the chief of state, or of the Prophet Muhammad. So except for religion and politics, you can say anything you want to. It's kind of like doing a comedy club, you know, or something, and trying to avoid those topics. A little hard. So I think it's an interesting aspect of the Sullivan case, the enormous admiration people have for that ability of media to navigate around public officials and realize that there isn't going to be a seditious treatment. Though in many countries there is, even in some unusual places like Monaco, where people criticizing Prince Albert in the last year went to jail for it. And you don't think that's something going to happen in Monte Carlo. You think of that something in Baghdad. But there you have it.
Can I jump in with one
yes.
other thing here that I think might be worth touching on regarding Sullivan, at least? And I'm thinking particularly of Canada and the UK, who have both in recent years, I think maybe Australia is in the mix too, but particularly Canada and the UK have wrestled quite explicitly with whether it makes sense for them to adopt essentially a Sullivan standard. And if you read, as I have at least a handful of Canadian and UK cases on libel, they're not comfortable with going as far as the Sullivan standard goes. But they have moved, and maybe Sullivan played a role in pushing this, they have moved, at least on paper, in the direction of providing more protection for libel defendants. The interesting thing is that I read them as taking much more the route that Justice Harlan suggested in the Butts case against the Saturday Evening Post, and talking about the conduct of publishers, the conduct of defendants, and
nice guys like Rupert Murdoch. No doubt.
Yeah, and looking at what are the media's judgments regarding what is appropriate ethical news gathering and reporting technique, and building that in together with some sort of concept of the public interest. Another thing that's an incredibly vague concept, of course, but still stopping short of the Sullivan standard. So there's a real consciousness, in other words, I think, of Sullivan, and a real thoughtful discussion of Sullivan going on in other legal systems as well, but nobody is willing to go quite so far. And again, I think one of the things that illustrates is that again is an area in which law and ethics are really bumping into each other. And of course, that's been a long-time fear of many journalists in this country, is that we've got to make sure that when we write an ethics code, for example, we don't write something that can be useful to people who are suing for libel or invasion of privacy or whatever it might be, because it proves that they behave poorly. So I think that's a significant development, and I think in part we owe it to the discussion that we began here with the Times decision, Sullivan decision.
Well, thank you all very much. I think it's time now we should have some comments and questions anybody wants to raise, and if you just stand up, identify yourself, and speak. Oh, the microphone's great. The mic will come to you. If you don't ask questions, I'll start asking you questions.
Behind you.
Bill Babcock. Bill?
Thanks very much. The one thing I don't have in common with the panelists is I was never one of Don Gillmor's students, although a colleague. So I don't have quite the deference to him that I think that you all did.
It's more like terror sometimes.
A number of you have mentioned the different ramifications, the ways particularly New York Times versus Sullivan can be seen, from an ethics perspective and also from a civil rights perspective. Those two perspectives usually aren't given all that much play in schools of journalism or mass communication, where law professors usually focus on the implications for the First Amendment. Would it be good if J schools in general might open this discussion up more than has been done traditionally, so that these cases might be looked at in a broader perspective, particularly New York Times versus Sullivan, the huge civil rights ramifications, the many responsibility issues that Herbert mentioned, and also the responsibility is mentioned issues that Beth mentioned.
Can we get a quick vote first, and then if somebody would like to answer more substantively, yes or no? Or it depends.
I'll say yes. We can go down the line.
Okay.
Yeah.
Beth?
Absolutely, I do. I talk about it.
Bob?
Yeah, I talk about it, absolutely.
Yes. Yes.
Yeah.
Okay, anybody want to answer more?
But
It's one of the most fun parts about New York Times versus
Home
Sullivan
run,
is talking
yeah.
about how,
Yeah.
luckily I teach in the North, I have to say. If I taught it in the South, I might phrase it differently. But I talk about how Southern white officials were using libel law in a very crafty way to try to shut down coverage of the civil rights movement, and how the case blew that apart. Mm-hmm. And I think it's incredibly, we would not have, I mean, as Herb pointed out, we would not have the country we have today had the justices ruled the other way.
Sullivan is really a slap suit, is what it is. An early example of I can never remember what SLAP stands for, strategic litigation against public participation, if I remember right. And I think that's really what it was. But that said, I do think I could bring no evidence to bear for this generalization. But I do think that in journalism education, at least, we probably have a tendency to teach law from the perspective that most of the time the media are right. Mm-hmm. And to the degree that we
First
do
Amendment
that,
exceptionalism.
yes, right? And to the degree that we do that, I think we do a certain disservice. It's I would guess it's the rare class in which somebody stands up. It's rare in my class, and says, I stand up and say, I think the court just got this wrong.
Teach in a business school sometime, and you'll meet those people.
Yeah.
And I think in communications education, we would be well advised, again, to look at the degree to which we over-silo things. One of the things that I was thinking about in preparing for this panel is how much of our colleagues in schools of communication who could study such things as political communication contributed to our understanding of what's going on today with social media and this sort of thing. We tend to divide ourselves up into these, I'm a media law scholar, I'm a social scientist, and that sort of thing, when actually I think our social role is to bring different perspectives to bear on the analysis of social and professional and institutional problems related to communication in the United States. It's what makes us different than being a law school or being a political science program or something.
Well, we should say too, that's many of us came to study with Don Gillmor because
exactly.
Both legal scholarship and social science. Are there some other comments and questions folks have? Up here, yes, sure.
I'm Ryan in the School of Journalism. How do you compare, in the context of these cases, Bradley Manning or Snowden or Assange to Daniel Ellsberg and what he did?
Well, Ellsberg had to work with a Xerox machine. He literally made these copies of the Pentagon Papers, many volumes of them, snuck them out of his workplace and this sort of thing. One thing that is clear, is not only has contemporary communications technology changed the press, it's changed leaking dramatically. Another thing, particularly about Snowden, is Ellsberg didn't flee the country. Snowden did. And that's another example of the globalization of this sort of stuff. WikiLeaks, it's not the New York Times, CBS, and others who distributed the Pentagon Papers. It's distribution. Fundamentally, I think questions are about the same. The outcome of New York Times versus United States was a sense that, generally speaking, it's the job of the government to protect its secrets. And if they leak out, that's the publication of that, absent some Near versus Minnesota based problem, is constitutional under the First Amendment. It hasn't changed so far. The one thing I would point out is that, thank God, our First Amendment survived 9/11. You know, we have all kinds of disputes and arguments about many things, including national security operations and this sort of thing, ways our society has changed. But 9/11, I think, ran the risk of leading the Supreme Court to overturn a bunch of First Amendment protections conceivably.
And it didn't happen.
And it didn't happen.
Right, yeah. Okay, thank you. Other comments and questions? Sir.
Hi, I'm a first-year law student at the U. My question was about, with the social media, everybody, you said, has become more or less a journalist. So I was wondering if you believe that that basically means that everyone has a responsibility of a journalist before sharing or retweeting something on the net, and if they do, when? I mean, if we do, then when people should be educated about those responsibilities, and maybe how or who should be responsible for such education?
You were talking about people who are using social media who are not journalists, right?
Right, just everybody. Yeah. Let's say there's a disaster and we have some controversial news, and people just share it without thinking about it. And
seems to me the nature of social media and citizen journalism is really outside of the realm of education and training. I don't know how you would ever get to it. They could have websites that would direct people, but I see no way you could possibly control that. It's just it's in the ether, and they're going to do it. Is there another question? Zach?
The power of the microphone is I can sit down.
We're looking forward to hearing your remarks.
That's later.
Later.
Actually, I'm a 54th year student in the law school. I want to report something that somebody said. It will not surprise you that I have been to a few conferences about the New York Times against Sullivan. And somebody made a very interesting, to me, comment about civil rights. Because at the time I was clerking, I was a sentient human being when the case was decided, and I thought it was a tremendously important civil rights case. What this person pointed out was that between 1960, when the Alabama State Trial Court ruled and gave him his $500,000, Sullivan, and all the other suits were brought. And 1964, March of 1964, New York Times against Sullivan, there were great progress of various kinds being made in civil rights for that period of 4 years. And that therefore maybe this didn't have quite the inhibiting effect that one would think. And then the next day, because I have a friend in Montgomery, I went down, and there is, if you don't know it, it's worth it to me, a whole trip to Montgomery to see the beautiful, small, beautiful mail-in monument to the civil rights movement. And it's a bunch of, it's a black disc with lines going through around it, from the center and around. And the first line is Brown versus Board of Education. And the last line is the assassination of Martin Luther King. And it has, most of it, it records deaths of civil rights, people in the struggle for civil rights. But there are, including Brown versus Board of Education, there's a line there for the Voting Rights Act, there's a line there for the Civil Rights Act. There is no line there for New York Times against Sullivan as being a great landmark, at least from that perspective. And I wonder, it led me to wonder whether this isn't just us Northerners thinking that what the New York Times had to say and getting it down into Montgomery was what's much more important than it was, and that it was the people in the South who did it without any help from the New York Times or CBS, or with little help. Now, There is another, I rush to say there are other views, and I've heard civil rights leaders of the time say that it was important. But I think we should, as we're supposed to be about everything, we should be a little skeptical about how much the notion of its importance isn't a peculiarly northern, peculiarly almost elitist a view of the impact of the case and what it was about.
Thank you. That's a powerful statement. Thank you very much. We're all looking forward, Judge Sack, to hearing your remarks later. Oh, okay. Later today, and honored that you're here with us today. Other comments and questions anyone has, and we're moving close to. Are we at the? No, we've got some time.
If I may offer one comment, I've noted one thing that hasn't come up in this discussion is what was the alternative remedy that the Supreme Court imagined for libel to public officials in New York Times versus Sullivan? The alternative remedy was they had access to the media. They could speak. They could call a press conference. If something false was said about them, they had a response. Mm-hmm. One of the criticisms of the progeny cases has always been the poor private person doesn't have any way to set the record straight. They needed the libel damages, and now it's harder for them to get. Mm-hmm. I think that basic model is fundamentally stressed by the emergence of social media. You know, the private person does now have a way to respond. It may not be effective.
And it may not be,
okay.
It may not be widespread either.
Well, it's very widespread. It's the whole world.
Well, okay. It may not have a lot of readership.
That's what's changed, though.
Yeah.
You know, if the Supreme Court said we can get rid of libel damages for public officials because they don't need it, they have another way to redress harm. I think a 21st century consideration of the place of libel in this thing requires going back up to that thing when everybody has not become a journalist, but everybody has access to very large audiences to spread what they want to say. And how we redo libel law to fit into that is something I think we have.
What was the phrase? Even the lonely pamphleteer that Don used to cite fairly often. I remember he also was particularly delighted in a reference to Floyd Abrams describing his defending NBC in the Wayne Newton case. And he arrived in Las Vegas. The case was argued in the federal court there. And he said, I drove up to the courthouse, and when I noticed it was on Wayne Newton Boulevard, I knew we were in trouble.
Ev, can I just say,
yes, please.
Respond to something that Judge Sachs said, which I think is really interesting. I think it's one of the things that I think that we often lose sight of, is that we often talk about these cases, but we lose sight, I think, sometimes of the historical movements that these cases arise out of, right? And it's more, I think, than just these cases. It's more than just the Sullivan case. You know, the Sullivan case is in many ways the result of something else that's going on. And, you know, we sort of, I think we do an injustice to those cases when we lose sight of those larger societal movements. And I think that, and I think your discussion of the monument or the memorial really sort of brings that out, right? That, and sort of forces us to realize, oh, it's just not this, it's all of this.
Can I jump in with a...
We have time for another comment or two, and well, we're the only thing standing between you and the coffee break, but before we get to that...
Let me stand between them. Just let me add my presence.
Briefly.
Yes.
Okay.
Because these comments have led me to think about three things. One is I think we can't forget that, harking back to the discussion about the civil rights case issue, is that Sullivan cuts both ways. We tend to think about the case as being something that provides great protection to the media, great protection to speakers, and so on, which I think we can easily fall into the trap thinking, meaning it protects the good guys, right? But it doesn't necessarily protect the good guys, and it gives just as much of a weapon for political attack, if you will, with impunity to the bad guys. Mm-hmm. Second thought that I
Lots of mafia people have taken advantage.
Yeah.
Yeah.
Is that the elephant in the room, I think, or there is an elephant in the room, and that elephant is has to do with the fact that we are constantly talking about, and understandably so, these cases which impose restriction on government. I think the elephant in the room these days, and it relates back to social media, and it relates to things like the regulation of cable television. It relates to the issue of net neutrality that is politically still controversial, and that is the huge issue facing us, I think, is not censorship, not prior restraint by the government, but prior restraint, censorship, if you will, by the private sector. Because we are all increasingly dependent on pipelines coming into our home, whether it be cable, whether it be internet, whatever, that aren't controlled by the government directly. In fact, they're increasingly been deregulated by the government, but these people have a chokehold, if you will. And we can't go to court and argue that, you know, Charter Communications has somehow wrongfully censored particular content that I want flowing into my home. And it's going to be a huge challenge to deal with that. And these cases, important as they are, aren't much help in that regard.
Okay, let's hold these thoughts. We are at the end of our hour, and I did want to take just one moment to, this is another topic for another panel at another time, or a book that someone could write, and I recommend you do that. I'd like to say that Don Gillmor had many admirers and friends, and many people benefited from his great work, and I don't normally speak for other people, but I think I can speak for everybody on the panel and everybody who was ever in his classes and benefited from his books, that we are the people who took Don away from the wonderful Gillmor family who are here with us, and the magnificent Sophie and Peter, of course, and Vivian and the grandchildren and Mary. Thank you very much for letting us share Don with you, because many of those nights when he was in his study reading the junk we were writing, you were waiting for dinner and all the other kinds of things, and we want you to know our enormous appreciation for that. So thank you all very much. And thank you to members of the panel.
So if you don't mind applauding again, join me in thanking this great panel, and particularly of Dennis, who just did a masterful job, I think, of moderating the discussion. Thank you so much. Okay, so now, as I've said, we have a break, 15 minutes, and we're going to hold you to that because we're on a tight schedule today. So there's beverages out in the hallway. Please go out and enjoy them, but please be back in your seats at 10:30 for the academic panel. Thank you.